And counsel for the appellant, please introduce yourself and your client, and then you may proceed with your argument. After the bailiff calls the case.
Thank you, Justice Eaton. Good morning, Your Honors. The matter before the court this morning is the case entitled Conkey versus S, 24 AP 149. Representing the appellant, Richard S. and Robert S. et al., is attorney Peter Langrock. Representing the appellee, Gretchen Conkey and Jacqueline Schmidt, is attorney Leslie Detman.
Once you may proceed.
Please, the court, this involves a prescriptive right to an easement granted over Wolf Road. Wolf Road is a road leading from Lake Street straight down to the lake. The plaintiffs have two other access. One, they have a 20-foot right-of-way adjacent to and immediately parallel to the Wolf Road, and the other is Lakeside Avenue, roughly 100 feet to the south. For many, many years, the parties were good friends and neighbors, and the court found that the use of Wolf Road by the plaintiffs was consensual. In 1995, something happened which they claimed turned it around. This is when the 911 was designated addresses for emergency use. At that point, the court points out that the plaintiff, one of the plaintiffs, received a sticker saying that the address was now 911 Wolf Road, and she had the belief that that gave her a right to use Wolf Road. And no, there is absolutely no legal right to use this road. It's only by prescription. Up until 1995, everybody agrees that it was permissive, and at that point, apparently the 911 was the point of changing it. In looking at the situation overall, the case law makes it clear that the purpose of the one thing that is required in obtaining an easement is notice. That when you talk about hostile, you're talking about enemy, you're talking about unthrowing the flag. All of this is the purpose to say, if you have your rights are being attacked, and you have to take steps to protect them. There is nothing in this case to indicate our clients were ever put on notice.
Counsel, would you address that comment to the signage and the mailbox?
Yeah, the mailbox is sort of ludicrous. It's just one of an unmarked mailbox on the far side of the road with a bank of other boxes for all sorts of buildings in that area for the convenience of the mailman. The signage is, Your Honor, the court found that there was no prescriptive right to have signage there. We don't know who put them up. They were accurate. They indicated where the properties were and for emergency addresses, but they certainly weren't an invitation to the Smiths to make a claim of right. There's a long way from making a claim of right, and that's the. I hope that addresses any question you may have on it, Your Honor. But
yes, thank you.
The other thing they talk about is, by the way, the signages were not on my client's property. My clients had no control over those, and they were not dishonest. If that is unfurling the flag, if this is the thing, we're the enemy. It's almost like the situation where they claim that they were maintaining potholes. They have a youngster. The only evidence they have is a youngster driving a little tractor and the thing. And if he is the enemy, and that's the putting it on the nose of this situation, it doesn't send to me that way. What the real situation here, and the thing that we're arguing about, is that as a very important part, if not the total part, the court should not have considered the subjective belief of the plaintiff that they had a right now because of 911, which they didn't have. It was a false thinking, and they didn't communicate it. So that my clients have no idea how put yourself in the position of the S's and saying, when does it happen? When does this friendly relationship turn into hostile? When is the flag unfurled? When am I told that I've got to be careful of my rights? And the answer is it never. And the time came when the use started to be changed by the Schmitz in terms of the commercial situation and the situation in terms of they were told not to use the right of way and the roadway. So that basically is that there is no warning to the essence that their legally deeded rights were being challenged by under a claim of right in a hostile way by an enemy was unfurling its flag. It continued in the same fashion. There's some evidence that was the increased use, but not significant. There are no different uses, and there's a claim that the tradespersons used it. That was not sufficient time-wise to have anything to do with this case, and the emergency situation is always there. I mean, my favorite Vermont case is Plouffe versus Putney, the old law school case about using an emergency for uses, and that's always been open. And
all right, and we'll have to leave it there, counsel. Your time has expired.
Thank you.
Thank you. Counsel for the appellee, please introduce yourself and your client, and then you may proceed.
Thank you, Your Honor. Leslie Detman, Your Honors. On behalf of appellees Gretchen Conkey and Jacqueline Schmidt, co-trustees of the Schmidt Living Trust. May it please the court. The appellants have asked the court to determine whether the trial court erred when it considered the Schmidts' subjective belief as to a claim of right to use Wolf Road, which changed after the implementation of the 911 system to conclude that the Schmidts have a prescriptive right to use Wolf Road. The court did not consider the Schmidts' subjective belief as to a claim of right as the basis for a finding of a prescriptive easement. Rather, the court noted that the Schmidts' subjective belief of a claim of right was the basis for the objective manifestation of such claim, including by erecting signs at 2 points along Wolf Road, which directed mail, service, and delivery people and invitees over Wolf Road to the appellee's address of 223 Wolf Road, erecting a mailbox to receive mail at 223 Wolf Road, and making more regular use of Wolf Road, again, after the address was assigned. And
I'd like to, if I might, sorry to interrupt you, but with respect to the mailbox and the signs, first, my understanding is the mailbox was off premise and with a bunch of other mailboxes and no identification as to whose mailbox it was. And with respect to the signs, they were also off premise, as I understand it. So my question is, where is the outer limit by which someone can create a hostile situation when they're posting nothing on the property in question, but remotely?
Thank you, Your Honor. The mailbox was installed in a bank of mailboxes with all the users of Wolf Road or the recipients of mail on Wolf Road, those who had a deeded right-of-way to use Wolf Road, which my clients did not have. So the fact that it was not in the right-of-way itself, I think is it's close enough in that, I mean, I think that is within the line in that it would have been sufficient notice to appellants because again, it was within the mailboxes where all others received mail. Again,
let me stop you there before you get to the signs.
Sure.
Are you suggesting that these folks should have counted up the number of mailboxes and realized there's an extra one? I'm hard pressed to understand how an additional mailbox in a string of mailboxes that's not identified has any bearing on what's going on here.
Thank you, Your Honor. I would say that I don't know that it's necessarily a matter of counting up the mailboxes in a string of mailboxes, but as between neighbors using and users of Wolf Road, the appellants would have seen, had reason to see the appellees receiving their mail at Wolf Road, picking up their mail, and traveling to and from or up and down Wolf Road in order to retrieve their mail.
Is there evidence in the record that they did in fact see them pick up their mail at that box?
There was evidence in the record, Your Honor, that yes, Your Honor, there was a question as to, I mean, I think it was a question as to what the appellees had personal knowledge of, and so there was question as to what the neighbors would have seen, and it's not my recollection as to whether or not there was specific testimony as to the S's having seen the use that appellees made of Wolf Road, but that other neighbors would have seen them traveling to and from the mailbox.
All right, thank you. And if you would just briefly speak about the signs. I interrupted you when you were talking.
Thank you, Your Honor. Thank you. I don't mean to interrupt. Thank you, Your Honor.
No, that's fine.
The appellants assert that the two directional signs which directed traffic to 223 Wolf Road were not located on the property and were not sufficient notice of the claim, and therefore can't form a sufficient basis for a finding of hostility. But both signs directed traffic, including the S's, who would view them on the way to the S property over Wolf Road to the Schmidt property. So the fact that they were not located on the S property is of no moment. They were notice to the S's who necessarily passed by them traveling to the S property that the Schmidts had a claim over Wolf Road. That is unequivocal notice indicating that this wasn't merely a permissive neighborly use of a summertime camp, but of a resident who received mail, deliveries, and invitees over Wolf Road and who had a prescriptive right to use Wolf Road.
All right, thank you. And you're going to have to leave it there. Your time has expired.
Thank you.
And is there any time remaining for the appellant?
Appellant has 0 time remaining.
All right, very well then. Thank you both. The bailiff may call the conclusion of the case.
The next hearing for the court is scheduled for 9:45 this morning.